month, and we're attempting a second mediation for this case in December at the end of this year. So once those matters are resolved, Your Honor, we should be ready to proceed for trial. And I see that counsel for plaintiff has joined.
Okay.
I apologize, I'm late, Your Honor, but I heard the end of opposing counsel's statements, and I wholeheartedly agree. That's where we are at.
Okay. When would you guys like to be reset to?
I think this coming spring would just be fine, depending on your court's schedule, of course. I would think March is sufficient, more than sufficient time for any outstanding matters, including, doctor's depositions, mediation, any other final things that we need to cover in discovery. I believe March is adequate time.
That's correct, Your Honor.
Okay. We have the 2nd, 9th, 23rd, and 30th.
One moment.
I don't think the second works for me, but the other two do work for me, Your Honor.
The 30th works for us.
I will say this case is getting pretty old. If it weren't for COVID, I'd probably be giving you a little bit harder time, but I have no idea how I'm going to try all these cases. And so just be aware that we're starting up trials very, very slowly next month. So in November, and then hopefully by March, we'll be back to some semblance of normal. So so just be ready to go in March.
Will do, Your Honor.
Yes, Your Honor.
All right, great. Well, you guys be safe out there, okay?
All right. Thank you, Your Honor.
Thank you. All right, so we have the prove up involving Irma de la Garza versus Raul Rodriguez. Is that right?
Yes, Judge. Lane Addison on behalf of the plaintiff.
And
The interpreter would request that the parties speak a little louder in the mic.
So, Yvonne, can you hear me?
Yes, now I can hear you much
Okay.
better. Thank you. Senora, is this your client, Mr. Addison, and the Lane Addison window?
Yes, that is.
Let me introduce myself. Buenos días, señora. ¿Usted es la señora Irma de la Garza? Are you Miss Irma de la Garza?
Sí.
Ok. ¿Puede hablar un poquito más duro o acercarse un poquito al micrófono porque me cuesta escucharla?
Está
You
bien.
could speak a
Ahora
little
sí.
louder or get closer to the mic, that would aid.
Sí. Ok.
Okay. Muchas
okay,
gracias. Yo estoy aquí para servir la intérprete, señora. I'm here to be your interpreter, ma'am.
Gracias.
Thank you.
okay, let's go ahead and I guess get started on this prove up. It's cause number DC 1920164, Irma de la Garza versus Raul Rodriguez. Tony, we need to go on the record for this. Counsel, make your appearance.
Judge Lane Addison on behalf of plaintiff Irma de la Garza.
All right, let's go ahead and proceed.
And Judge, I would ask the court first take judicial notice of the case file and the contents therein.
Okay.
And then I call as my witness Irma de la Garza.
All right, first let me go ahead and swear in the translator. Do you swear or affirm that you will translate the matters in this case from English to Spanish, from Spanish to English to the best of your ability, so help you God?
Yes, I do.
And could you state your full
Giovanna
name?
Gonzalez, Master Licensed Court Interpreter for the state of Texas, license 2343.
Okay, great. Let's go ahead and swear in the witness. Do you swear
Señora
or
Irma,
affirm?
por favor, levante la mano derecha, señora Irma, para que usted pueda hacer juramento.
Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Usted jura solemnemente que el testimonio que va a prestar en este caso será la verdad, toda la verdad y nada más que la verdad.
Sí.
Yes, gracias. Puede bajar la manita. Thank you. You can put your hand down.
Let's proceed.
Now, Ms. de la Garza, we are here concerning a house located at 10319 Seagoville Road, Dallas, Texas 75217. Is that your home?
Señora de la Garza, usted está aquí presente tocante a un asunto que tiene que ver con la casa que está ubicada en la 10319 de la Seagoville Road en Dallas, Texas, 75217. ¿Esa es su residencia, señora?
Sí, señorita.
Yes, ma'am.
And you purchased this home, I believe, in around 1991, correct?
Y esta casa me parece que usted lo compró en 1991. ¿Es correcto?
Sí, señorita.
Yes, ma'am.
And when you purchased that home, you were not married, correct?
Y para cuando usted compró esa casa, usted no estaba casada. ¿Es correcto?
Es correcto.
That is correct.
There's also a named defendant in this case, Raul Rodriguez. And for the court's benefit and information, Mr. Rodriguez was a gentleman you had a personal relationship for many years with, correct?
For the they interpreted in here the end of the question. For the some knowledge, Mr. Rodriguez was what?
Had a personal dating relationship with for
Oh,
numerous years.
Okay. Para que sepa el tribunal, el juzgado, el señor Raúl Rodríguez, para cuando usted había comprado la casa, no habían tenido todavía usted y el señor Rodríguez una relación íntima. ¿Es así?
Es así.
That's correct.
And you were never married to Mr. Rodriguez, correct?
Y usted nunca se llegó a casar con el señor Rodríguez, ¿es correcto?
No, señor. Es correcto.
That is correct.
And when you purchased the property on Seagoville Road, did you purchase that by yourself or was Mr. Rodriguez involved in that purchase?
Y para cuando usted compró ese bien inmueble en la calle de la Seagoville Road, ¿usted lo compró solita o el señor Rodríguez estaba involucrado en la compra de esa propiedad?
Sola.
Alone.
And you never transferred your ownership in that property to Mr. Rodriguez, correct?
Y usted nunca transfirió el interés de propiedad al señor Rodríguez, eso lo mantuvo a su nombre, ¿es correcto?
Es correcto, señorita.
That's correct, ma'am.
And Judge, I don't know if I can share my screen. I'd like to show her the general warranty gift deed that's attached to the amended petition.
Okay, go ahead.
Se le va a compartir la pantalla para que se pueda ver el título.
Is it showing up? How do I, okay. Miss De La Garza, right here in front of you right now is Exhibit 1 attached to our amended petition, which is called General Warranty Gift Deed. Do you see that?
Señora Garza, aquí en la pantalla ahorita se ve el anexo que es el elemento de prueba número 1, que está titulado Escritura con garantía de título o documento de garantía. ¿Alcanza a ver la pantalla, señora, el documento?
Sí.
Yes.
Sí.
Yes.
And on the second page of this, there's a signature that purports to be your signature. Is that your signature on this gift
No,
deed?
no.
Y en la segunda página de este documento, ahí se puede apreciar que hay una firma. Es la firma suya, efectivamente, la que aparece encima del nombre suya, señor.
Yo no he firmado este papel.
¿Cómo?
Yo no
Excuse me?
firmo este papel.
¿Usted no firmó ese papel?
No, no he firmado.
No, I had not signed that. I didn't sign that paper.
And Judge, I'd like to offer Exhibit 1 as part of the record of this hearing at this time.
Exhibit 1 is admitted. Have you already emailed the court coordinator that?
Judge, it was, I don't know if I've admitted, if I've done it. I know it's attached to our amended petition, but I can certainly forward this as a separate Exhibit 1 to the court coordinator after we conclude
Go
here.
ahead and email the court coordinator after this hearing is over.
Sure. And Judge, that's all the questions I have for this witness.
Okay, call your next witness. Or any cross-examination? Okay, call your next witness.
Judge, I don't have any other witnesses to call this time. I would just ask that the court take note, based on our petition, our amended petition, that the court judicially strike this deed and give us a judicial finding that the plaintiff is the sole owner of this real property.
Okay,
Se está solicitando ante el juez, ya que se han presentado los elementos de prueba para que consten en el acta y ya que han sido entablados ante el tribunal y no hay ningún otro testigo ni ningún otro elemento de prueba, se está solicitando por parte del demandante que el juzgado, por favor, declare nulo lo que es este documento de garantía con este elemento de prueba.
All right, the court will go ahead and grant the relief as requested.
Thank you, Judge. And I've got an order submitted already, but
I've signed it.
okay,
I just signed
perfect.
it. All right,
Judge.
you guys be safe.
All right, Judge, thank you.
Se permitió el amparo como ya lo solicitó el demandado, la demandante. Está otorgado. Muchas gracias. Thank you, Your Honor. Is the interpreter excused?
Yes, thank you very
Okay.
much. And so is
Thank
the
you,
witness.
thank you, Mr. Addison. Señora Irma, ya usted también ha terminado con su testimonio. Ms. Irma, you have finished with your testimony as well. Thank you. Gracias.
Thank you, Judge.
Y'all have a good day.
So let me just do something on the record. I thought I saw Mr. Siderman come in. Is he not here or is he here? Mr. Wine or Mr. Nunn is your opposing counsel here.
Thought I saw him there for a second, Your Honor. It looks like he dropped off.
Okay. Do you want to go ahead and call him and something strange has happened. I just wanted to kind of chat with you guys about it.
Sure, I'll give him a call.
Good.
All right, we're done. We just signing order. Now we go to the talking order.
Let's see. The person's still talking. Okay, so Mr. Wide, why don't you call your opposing counsel and see if they can get on the phone. Mr. Pauly, what are you here for?
Would you do that, please? See if you can reach this Pinson.
Your Honor, I was
Pinson.
informed by email a little bit ago that we could have a hearing on more than 55 jurors in the Mcallen case.
With Alex Hernandez.
I don't know that everybody
Pinson. He's the guy that was on the computer.
Okay, so you're here about the 55 jurors for the special setting in January?
Yes, sir. All the defendants are on. I don't know if the plaintiffs are on.
Plaintiffs
They're
are
the ones that called the party.
I'm here, Your Honor. Steve Davis on behalf of Ms. Mcallen.
Okay, give me I don't have this case. What's the cause number on it?
Bruce, can you help? I got notice of it about 15 minutes ago, and I'm in my car.
Yeah. It is DC 18-04143.
DC 18-04143. Okay, I just wanted to kind of chat with you guys about this. As you probably have guessed, Dallas County has not had any jury trials since March. We have tentatively set a very, very small number of trials in November. I don't know kind of what is going to be happening in January in terms of trials. So I just kind of wanted to touch base with you guys and see if you wanted to maybe move your special setting, or do you want to kind of just wait and see what happens? I just don't know if by January we'll be able to get 55 jurors, and I just don't know, because with the state of the pandemic, it's still very much up in the air.
Well, Steve Davis on behalf of Ms. Mcallen, Judge. I mean, we had talked about in June just kicking it to June, and we kind of settled in on January. I think myself and everybody else included would prefer to have a fairly firm setting given our experts, and it'd be really nice to be able to bring some of our experts live. And so with some certainty, I think it would make it easier, on the group. So
I'm happy to, I don't usually do this, but given kind of this isn't y'all's fault at all, I would be glad to set it as a special setting if you want to. I mean, if somebody really wants to keep it on January, and I'm not trying to, and I know this was kind of last minute, so I'm not trying to, I'm just trying to accommodate and kind of keep you guys updated. And if you guys say, hey, look, I'm not ready to decide this right now, I'm glad to let you guys talk and then come back to me. I'm seeing how this is all developing at the court, and I think we might be able to get a trial by then, a trial of this size, but I don't know. And so I know these cases are very expensive to trial. And so I'm happy to reset it to June or July or whenever you guys want to do it. I'm glad to keep it in January.
Well, Judge, I'd be in favor of moving it to the summer.
I'm not even 2 of us.
You guys say who you represent, just say plaintiff or defendant.
Bruce Pauly, representing Dr. Leach and IPC. And I'd be in favor of moving the trial until June or July.
Steve Davis on behalf of Tiffany Mcallen, June or July.
Is that the plaintiff or defendant?
Plaintiff, Your Honor.
Plaintiff.
I'm sorry.
Do you want me to reset it right now, or do you guys want to talk about dates and then get back to me, or kind of what is your preference?
Well, I don't know. I can't speak for Tim and Casey, Tim Ryan and Casey Campbell. I think they're on, and they represent the other defendants.
Okay.
Your Honor, this is Tim Ryan speaking on behalf of the 4 hospitalists who've been named: Dr. Okoli, Dr. Wary, Dr. Fairweather.
It doesn't matter. What is y'all's position on this?
I think it'd be useful. I would favor the summer as well. I think it would be useful for me to be able to have contact with my clients about it, to make sure that they don't have any intruding kind of matters on the calendar that would need to work around.
I give you some dates in June and July of next year. So we have June 1st. You guys might want to write this down. I know one of you is driving. I apologize. But it's June 1st, June 8th. How long is this going to take to try?
Couple weeks.
Couple weeks, okay. So June 1st, June 8th, June 22nd, if you can do it in 2 weeks. July 13th, July 20th. So those are the dates we have available. And the one thing I would say is that I'm constantly trying to triage cases like this one. And so the longer you take to get back to me, the more likely we are to lose those dates. So as a special setting, so I would encourage you to try to get back to us as soon as you can with a date, because we may lose those because we're having to, you're obviously not the only case on the docket. And so I'd urge you to try to get back to me as soon as you can. Okay.
That's fine with the plaintiff, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
And if there's a problem picking a date, I'm glad to have a status conference to talk about it, whatever you guys need. I'm just trying to, I know these are expensive. I don't want you guys to spend $50,000 getting ready for trial and then we can't get you a jury. So I hope this helps, and hopefully by next June, everything will be back to normal. We'll be trying cases live, I hope. So we'll see. Okay.
Thanks, Your
Hopefully
Honor.
we'll have a vaccine and everything will be good.
Yeah, thanks very much, Your Honor.
No problem. You guys be safe, all right?
You too.
Thank you for your accommodation.
No problem. No problem. Thank you, guys. You have a good day.
Too.
May we be excused?
You may. You may. Thank you.
Thank you.
Mr. Nunn, is your opposing counsel on the phone, or have you figured out what's going on?
I haven't yet. I think Mr. White was going to call him. I guess Mr. White just got back on here.
Good morning, Your Honor. I asked Miss Payton, my legal assistant, who's off screen but listening to me, to attempt to reach, I believe is it Mr. Pinson?
No, Simpkins.
Simpkins, excuse me, Mr. Simpkins and Mr. Johnson. And I would ask her, what was the result?
I've left a message for both. I don't get an answer at either number that we have.
Did the court hear that?
Yeah, I did.
Here, let me just turn. This is
okay.
This is the very talented Miss Tina Payton, Judge.
Hello, Miss Payton. How are you?
Good morning, Judge Hoffman.
Well, let's. I really need both sides to be on the phone.
I'm trying to reach Mr. Johnson on his cell number, and I'm trying to call the Alex Hernandez firm for Mr. Simpkins, which is the only number that we have for them.
Okay. Even if we can just get one of the attorneys on the phone, I'd be okay with that. I just need to kind of
yes, sir. We'll keep trying.
Judge, we don't keep a cell phone in our conference. We don't keep a phone in the conference room so it doesn't go off during hearings. We do all of our video from one room, if that makes any sense.
Perfect. Okay. Well, once he gets on, we'll chat. All right. So do we have everyone here on the Cole versus Jackson case? I see Rachel Hatton. I don't know if there's anyone here with the defendants.
Yes, here for defendant Anthony Lascalia. I'll turn my video on. Can you guys hear me and see me?
Yeah.
Yes. Good morning.
Let's go on the record. So we're jumping all around, Tony. I apologize. It's just one of those days. We're going on the record on cause number DC 199708, Cole versus Jackson. Rachel Adams and William Tolles are the attorneys. Counsel, make your appearances.
Yes, Rachel Hatton Adams, counsel for plaintiffs Van and Benita Cole.
And Anthony Lascalia, attorney for defendant Denise Jackson.
Spell your name, because I don't think that's what it says on your screen.
Judge, my name? I'm Anthony Lascalia. Last name is Lascalea.
Let's go ahead and proceed. We're here on a motion to strike.
Yes, Your Honor. Plaintiffs has filed a motion to strike the counter affidavit of defendants, counter affiant Dr. Vicaria. Dr. Vicaria's counter affidavit does not go to the necessity of either plaintiff's medical treatment, purely the cost of the services rendered. So Dr. Vicaria's affidavit fails to meet the higher 18001F standard of not just providing from a qualified expert a reasonable notice of their opinions, but 18001F requires a reasonable notice of the basis of the counter affiant's opinion. And that's what's missing here. For example, as is quoted in the block quote on page 3 of our motion, Dr. Vicaria opines that for the initial service, the $907, which was charged and proved up under our affidavits, he opines that between $300 and $400 would have been the more reasonable rate. But he does not say specifically how he came to that opinion. Now, he cites globally that his opinions are formed from his experience, and he puts a little tagline in as buried in his affidavit that, oh yes, he's used, the Fair Health and other, databases of the physician's fees, but he does not say exactly how it is that he came to, for instance, the opinion of what an initial.
Ms. Hatton, can you just? I need to take a break. I need to have another hearing. We've been trying to get all the attorneys here. It's kind of an emergency hearing. So I'm going to, if you don't mind, just take a quick break from your hearing and go to the other hearing.
Yes, Your Honor.
I'm sorry, Tony. I'm sure this is not easy for you. I apologize. Mr. Nunn, can you go ahead and announce the case name, and I don't have it in front of me, the case name and number that you're here on?
Yes, sir. It's DC 20-09893 Moss v. Princip et al.
All right, and go ahead and make your announcement.
Yes, sir. Good morning, Your Honor. Hunter A. Nunn, N-U-N-N, Warrant to Nunn, and Dan White of White Associates, plaintiffs, justice, creditors, David Tyler Moss, and Brent, Fidelismus LLC. Excuse me.
And Mr. Michał Zapandowski of Sabady and Company on behalf of defendant Dayan Princip.
Oh, wait, say your name again. We haven't heard from you before.
No, you have not, Judge. So originally this case was in Judge Smith's court. My client is defendant Dayan, D-E-J-A-N, Princip. My name is Michał, M-I-C-H-A-L, Zapandowski, Z like zebra, A, P like Peter, E, N like Nancy, D like dog, O-W-S-K-I. Anyway, when the two cases were consolidated, that's when I entered into your court, and I did not participate in the events last week.
Okay. Mr. Simpkins, if you want to make an announcement.
Yes, sir. Philip Simpkins for Brian Martin.
Mr. Wide.
Mr. Nunn announced for me, and I'm co-counsel with Warrant and Nunn on this.
Anyone else on this case here right now? Okay, so I just wanted to, this is kind of unusual. So I've not had this happen before. This exact thing happened before. So partly because the era we're in, as I want to make it clear on the record, the court is doing this hearing via Zoom. We had a temporary injunction via Zoom last week on this same case. That temporary injunction pursuant to the instructions from the Office of Court Administration was streamed to YouTube. There was, as you recall, there was some unusual things that happened at that hearing involving the computer of the court being hacked. Anyway, I've been contacted in other cases by, pro se's, via private message or whatever. And I've always notified the parties in that situation because that's clearly an ex parte communication. I don't know, I wasn't really sure what to do, so I just thought I'd go ahead and just notify you that there was a post made on the YouTube channel that I have that from a person who I believe is Mr. Martin's ex-wife, Christy Larimore, is that what her name is?
Barmore, Your Honor, I believe.
Barmore. Alleging that, assuming that it was really her, that Mr. Wide had somehow pressured her into lying under oath in the hearing last week. I'm not saying that's true. I'm not saying that's even Ms. Larimore who posted that. But given the unusual nature of this case, I'm going to take that YouTube video and make it private, which is perfectly allowable under the Office of Court Administration's instructions. I don't really want this to be something that's attracting a lot of unwanted traffic, I guess. And so, but I'd also wanted to make sure, I didn't want there to be any type of I just wanted to let you guys know before I took that down and see if you had any questions. I don't know if this is true. I don't know. I'm not accusing Mr. White of anything, but I also don't want to hide any information that the court has received in this case. And so, has anyone else seen that post on YouTube?
I have not, Your Honor.
No, sir, Judge.
No, Your Honor.
What about the new attorney?
That was me at the beginning, Your Honor. I have not.
Does anyone have a preference on how I handle this? I could leave the video up for another few hours if you want me to, so you can look at it, or I haven't taken it down yet, or I'll let Mr. Simpkins kind of speak first.
Your Honor, certainly we would like to explore the comment. It certainly goes to the court entering of a temporary injunction, and we think it's significant. So yes, we would like to explore the origin of the comment itself.
I'm not going to delete the video. My plan is to make it private. So if at some point you guys want to, this is getting beyond my area of technical expertise, I would be glad to try to maintain this, but I do feel like I want to take it down because it is attracting a lot of, anyway. So.
May I speak?
Sure.
I think the court knows, as I previously informed you, that I have more to lose than any other person in this matter. And if
You don't need to say anything. I'm just notifying people. I'm not accusing anyone of anything, but I do want to be.
I'd like to inform Mr. Simpkins, because I'm not sure he's aware, and I don't know that he is in fact aware, and any other counsel involved. I am in receipt of 16 pages of text messages between the email address of I know it's kind of backwards, but this is Mart the Great, M-A-R-T-E-K, Martek the Great. This is one of the emails that Mr. Nunn submitted in the motion for alternative service for Mr. Martin, Brian Martin. These are 16 emails, or excuse me, 16 pages of text messages from the time of that hearing, the temporary injunction, through this weekend to Miss Barmore's mother, and I believe possibly to Miss Barmore. I wanted to submit an application for a protective order, as Mr. Martin is the one that is attempting to tamper with a witness, Miss Barmore. I didn't even know. I had no address for Miss Barmore until Mr. Martin put that in a text message. She has not even been served in this case with citation because nobody knew where she is. And my comment to the court is that I wanted the court, and I'm asking it to consider eventually, not right now, but to order Mr. Martin to personally appear at court. Eventually give him, if you give a direct order to a party in a case to appear, then, and if they fail to appear, that will ultimately be direct contempt.
Hi, how are you? Never mind. How are you? Good to see you. Sorry. We had somebody show up I wasn't expecting.
Excuse me. I just wanted to say, Judge, I have absolutely no reason whatsoever. And I'd never even spoke to Miss Barmore until 2 weeks ago. She wasn't even notified of the temporary injunction hearing until the morning of it, and only asked, and I will submit my emails to the court in camera, only asked if she wanted to appear. She appeared voluntarily. I asked her a question. Are you under subpoena, or do you appear voluntarily? She said, I appeared voluntarily. That is it. We know, Judge, I think it's a reasonable inference, and you will find out eventually that your computer was hacked by someone working with Mr. Martin. Nobody else involved in the call has the ability to do that. Not me, not Mr. Nunn. We're not computer, hacking capability type people. And what I'm trying to suggest to the court is, and I appreciate your professionalism, your calm demeanor, but this man, Mr. Martin, will say and do anything to destroy the integrity of these proceedings.
I'm not making any comment about any of this. I'll leave this up to Mr. Simpkins, though. There's two ways we can do this. I think, well, actually, I'm not going to leave it up to Mr. Simpkins. I think what I'd like to do is I'm going to give both sides an opportunity. I have to be honest, I'm not 100% sure that whatever was posted on the temporary injunction or just one of my other hearings. I think it was on the temporary injunction, but I'm not super savvy about this. I just got an email about it because every time there's a comment made on any of my YouTube videos, I get an email about it. And that's when I read it. So what I would suggest we do is, I'm not going to do anything to the YouTube channel. I'm just going to leave it up. And then I would suggest maybe we reconvene tomorrow morning and give Mr. Simpkins, Mr. Wyde, everybody involved an opportunity to take a look at it. It's possible that someone might have deleted it. I don't know. I just want you to have a full opportunity to look at this, and then we can kind of talk tomorrow morning, 9 o'clock, if that works for everyone, about what's going on. What do you think, Mr. Simpkins, about that?
I think that's fair. I think it's fair, Your Honor. No objection.
Okay, guys, that's all we have. I have a lot of other hearings, so I will see you guys tomorrow morning at 9. And Tony, let's go off the record on this one, okay?
Thank you, Judge.
Thank you, Your Honor.
Thank you, Judge.
We're going back on the record on Benita Cole versus Danae Jackson, cause number DC 199701. And Ms. Hatton, you were in the middle of your presentation. I apologize about that.
Absolutely not a problem, Your Honor. As I was saying previously, what is at issue here and why the defendant's counter affidavit fails is that it fails to provide a reasonable notice of the basis of the counter affiant's opinions. Specifically, he will opine and has opined in his counter affidavit that, for instance, $300 to $400 is the reasonable charge for a initial evaluation. $150 to $200 is a reasonable charge for a follow-up visit. His counter affidavit does not distinguish which of his sources, which of his bases he is using to form each specific opinion. We are left wondering. He cites globally that his opinions were formed from his years of experience in the practice, as well as the physician's fee reference guidebook, Fair Health, the prescription fee database, which in defendant's response, they've conceded is a reimbursement rate data. Only goes to the reimbursement charges, and there's a reimbursement company. So we have this hodgepodge of, I would opine or argue, okay basis of opinion and non-okay basis of opinion, and the counter affidavit mingles all of them together. We are left wondering which of these, of the 1, 2, 3, 4 stated sources of his opinion on top of his experience is he using to say what a reasonable initial consultation is? Which and how is he using these sources for what a follow-up charge? And then more importantly, which of these sources and how is he using the prescription fee sources as to opining as to what a reasonable anesthesia charge or epidural steroid injection should be? So because of this, the counter affidavit on its face fails to provide plaintiffs a reasonable notice as to the basis and how he's formed these opinions. As such, it's conclusory and it should be struck.
Judge, we filed a counter affidavit for plaintiff Benita Cole. Dr. Vicari is a board certified pain management doctor and anesthesiologist. Plaintiff's basis here is reasonable notice. In Dr. Vicari's affidavit, he not only lists his 25 years of experience as a pain management doctor and board certified anesthesiologist, he goes through everywhere that he has worked. He also cites numerous surveys and literature where he derives his pricing in his practice as in his own clinic. He has his own clinic and bills in his own practice as he states in his affidavit. In his affidavit, he does show the Physician's Fee Reference Guidebook, the Fair Health Consumer Database, the American Society of Interventional Pain Physician Fee Schedule, and the PS card prescription fee database. He then goes through in his affidavit each CPT code for each service provided and gives either a number or a small range on the lower high what it should be. He doesn't just say, trust me, I know the fee, or this is what it is. He goes through every single CPT code for the treatment and lists the usual and customary charges. Also, Recently in Dallas County, they have allowed virtually the same affidavit with similar pain management treatment in the, that would be in the 14th district of Dallas County, signed on June 2020, that this similar affidavit for pain management treatment did hold up to 1801, and plaintiff's motion was denied. So we feel that our expert here has gone through all the CPT codes and has backed up where he gets these numbers from, goes through every CPT code and shows the plaintiffs what he is actually controverting and what a reasonable range on low and high is. And Judge, it's not a very large range. He simply states on the low end 400, on the high range 500. So instead of giving an exact number for every single charge, he does go through them each one at a time and does have a small range of what each treatment should be. So for those reasons, we ask the court to deny plaintiff's motion to strike Dr. Vicari's controverting affidavit as to Benita Cole.
Response?
And Your Honor, it's not just what reasonable notice of his opinions, but it's the reasonable notice as to the basis of his opinions. Now, as to a similar affidavit that defense counsel is stating, I just looked into his response. I didn't see the affidavit that he's actually citing, but I would make a wager that that affidavit, if it was sustained or deemed to be sufficient, it would have given notice of the basis of that affidavit, counter affidavit's opinions. That's what's not given here. In his defense counsel's response, he cites to all of these sources that the doctor uses for his own practice, but that's not reasonable notice as to what the reasonable charge is in Dallas County for similar services rendered at the same time. For this counter affidavit to be sufficient under 18001, it needed to have provided us reasonable notice as to how he's using these sources, how is he coming up with these numbers, except for just what his practice charges. For all the reasons set forth in our motion.
Okay, so let me ask a quick question here. So, so his basis was, so let me just say kind of how I handle these, because I don't know how Judge Moyer handles them. And you know, he and I actually were on a panel once about this, and we actually kind of disagreed on how we handled it, but it's, you know, that's, every judge is different, and that's okay. And so this is how I handle it. I look at, first up, is it apples to apples? Is it the same kind of provider trying to challenge the same kind of a provider? So an orthopedic surgeon can't challenge a chiropractor can't follow it. So that hasn't been challenged here, it doesn't sound like. And so the next issue really is, if it is the same area, if it isn't apples to apple, and I always strike these billing records, custodians or auditors or whoever they are that aren't doctors, I always strike those. So it comes down to, in a situation where it is apples to apples, I feel like in any situation where they're relying on reimbursement rates, like Medicare rates, all that kind of stuff, I always strike that. So it sounds like partly this case was relying on reimbursement and partly not. Is that right?
And Judge, he just mentions a reimbursement rate, and I'm trying to find the affidavit where he references these. Give me 1 second, Judge. So he not only in his own private practice, because he provides this treatment daily, this pain management treatment, and he has his own clinic that he bills out of for the same treatment. He cites the Physician's Fee Reference Guidebook, the Fair Health Consumer Database, as well as the American Society of Interventional Pain Physician Fee Schedule Database and PC Card Prescription Fee Database. In his affidavit, he also states that he's taught pain management and he's worked at Southwestern Medical Center and the VA Medical Center, but I do not see in his affidavit where he puts any healthcare reimbursement rates.
Your Honor, in the defense own response on page 6 of their response, they cite and list the same sources that he uses, and also concede that the fee database is a healthcare reimbursement company. because, I mean, we know now that he's basing these on reimbursement rates, and because he hasn't parsed through and told us how he's using which source, the fruit of the tree, I mean, it spoiled all of the counter affidavit, because I don't know what basis is he using and how permeated these reimbursement rates are as to forming his actual opinions for all of these charges.
And Judge, I think that may have been a typo on my part. It's not in his affidavit. In his affidavit, he does cite these physicians fee reference guidebook, and also the American Society of Interventional Pain Fee Physician Fee Schedule.
Does he ever state that he's familiar with the rates in Dallas County and that these are above those rates or anything like that?
He does say they're inflated. He does office out of Dallas County as well. And he does mention just a portion of the fees were not reasonable. So he does say in his affidavit, he's not saying the treatment wasn't reasonable. He's just attacking the charges only in this case, saying that they're either inflated, they're excessive, or they're.
Does he ever say that the charges, he's familiar with the rates for these types of procedures in Dallas County? Does he ever say that?
He says he works as a private pain physician at the Texas Back Institute, Presbyterian Hospitals of Denton, Flower Mound, and Plano. He attaches his resume where he does office out of Dallas County. I'm taking a look at it now.
And Ms. Hatton, what I normally do in this type of situation is I'd recommend dueling affidavits, but I think your firm doesn't do that, right?
Correct.
And if there's any reason you see need that we need to amend or supplement this affidavit, we do want to ask the court for leave today.
Do you agree to give them the opportunity to supplement the affidavit?
I feel like they've had ample opportunity, but I'm not going to step on which way the court would like to rule.
No, I'm asking if you're consenting.
I don't believe I can, in the best interest of my client, consent to them having two bites at the apple.
Okay. I'm going to go ahead and strike the affidavit then, unfortunately. I think this one was pretty close. So do you have an order that you've submitted, Ms. Hatton?
Yes, I do. It's on file. I can email it to the court, CC opposing counsel as well for convenience.
Let me see if I have it. Yeah, I think I have it here. Okay, I'll go ahead and sign that. You guys be safe out there, okay?
Thank you. You as well, Judge.
Thank you.
You too, Anthony. Have a good one.
Thanks.
All right, Mr. Hunter, are you here for the special setting? Is your opposing counsel here?
I know one is, Your Honor. We have actually have an informal settlement, and an ad litem attorney has already been appointed for the interest.
Oh, you have? Okay.
Yes. So we filed a letter in the past, but we want to announce that we won't be going forward with the special setting. We have an informal settlement to resolve all matters.
And who's your attorney? Who's your guardian ad litem on this?
Oh, let's get this.
Did I appoint one?
Yes, Your Honor.
And that settles the entire case?
Yes.
The entire case is settled?
Yes, Your Honor. I'm pulling, it's Al Ellis.
Oh, Al, yeah, he's a great lawyer. Okay, yeah, he's appointed. So go ahead. Do you want us to are you going to be able to get approved up before November, whatever this date is, November 2nd?
I'd be happy to, but I need to probably check in with Al about how he feels. I think that it could, or soon after that.
Okay. we'll go ahead and right now it's set on November 3rd. Tell them I'd like to get it set before then if possible, or even on that date. But if not, then we'll just kind of deal with it then. Okay. I just wanted to make sure that we didn't need the special setting. So, and you guys be safe. Okay.
Thank you, Your Honor.
Thank you. Bye-bye. Are both sides here on Hunt v. Temple?
I believe so, Your Honor.
Yes, Your Honor. I'm Sam Pettigrew,
Okay.
the plaintiff.
All right, Tony, let's go on the record on cause number DC 209976, Helen Louise Hunt versus Bonnie Jan Temple. Counsel, make your appearances.
Your Honor, Amy Lorenz and Lori Shannon for the defendants, Bonnie Jan Temple and George W. Hunt.
Your Honor, Sam Pettigrew Jr. for Helen Hunt, plaintiff.
Okay. All right. So we're hearing a motion to dismiss. I've read the briefing. I did have one kind of serious question, which is I know that I think it's probate court number 3 in Dallas County has jurisdiction over mental illness cases. I've never understood it to encompass something like this. But does anyone have any case law or anything like that to indicate that they have exclusive jurisdiction over this?
Well, Your Honor, the issue is that if for argumento, there is a question of incapacitation, then the issue of whether a power of attorney is going to be enforced that's going to be thrown out the window, because now we're looking at the possibility of a need for guardianship, because we have a conflict of interest here, because there is a competing divorce proceeding that involves both Mr. and Mrs. Hunt, to where Mrs. Hunt cannot act as a power of attorney because that is strictly against the interest of Mr. Hunt, who she would allegedly have power of attorney over. So as far as what I'm aware, the exclusive jurisdiction for guardianships is under the probate courts in Dallas County.
We don't, that's not the issue here though. No one's asking to appoint a guardian. Is that right? Or
that is correct. What they're asking is to invalidate a power of attorney that was executed on July the 1st. And so if the court were to invalidate that, then there would be no power of attorney that could be in place, because like I said, there would be a breach of fiduciary duty, or Mrs. Hunt cannot act as a power of attorney for somebody who she is in a lawsuit against in a divorce proceeding.
Yeah, Your Honor, we're going to request an attorney ad litem for Mr. Hunt in the divorce.
And Your Honor, they have presented nothing that shows that there is any sort of incapacitation. There's no competent evidence that has presented other than just a fact opinion by a layperson. And even then, their pleadings, there's a judicial admission that Mrs. Hunt left Mr. Hunt for weeks or months on end to care for himself and maintain his personal assets and whatnot while she was receiving medical care. And then the moment she finds out that he has revoked a power of attorney, then she's claiming incapacitation. She can't have her cake and eat it too here of, well, I'm going to be leaving Mr. Hunt from February to June to live on his own, manage his own medical needs, his living needs, his financial needs, and then come back and say, no.
But are we kind of jumping the gun here? You're asking me to dismiss this on jurisdictional basis is what I'm not ruling on the merits today, right?
Well, we have it's under 91A1 and 91A2 that she's presented nothing that would give her the ability to get the relief that she's seeking. She's asking the court to declare that he's incapacitated.
But under Rule 91, don't I have to accept the pleadings as true? There's no requirement for evidence.
Well, that's where we're saying, Judge, even if you're accepting the pleadings as true, just how the facts are, she is living in Ohio. Even if you're looking at the pleadings as true, she hasn't stated that he has no ability to understand what he executed. Her pleadings merely state that he may have been unduly influenced by his daughters, which is extremely reasonable given the circumstances of what's going on. His wife was in a hospital and rehab for months. He moved to live with his daughters. His daughters and him discussed his condition. He believed that it was in his best interest to execute a power of attorney on July the 1st, naming his daughter power of attorney because he's residing with her. His wife is living in Ohio. So I don't think that they've even pled what's necessary to even be able to get the relief that they're seeking. They're not saying that he's in.
But the basis of your motion to dismiss is that I don't have jurisdiction because the exclusive jurisdiction is Dallas County probate courts. That's the basis of your motion to dismiss.
Well,
it also says there's no basis in law.
And that's where, Your Honor, they've pled nothing that I believe that the court is able to revoke this power of attorney, because the crux of their argument is that
I'm not revoking anybody's power of attorney today. This is only an issue of whether or not to dismiss the case. So this is not, I'm not taking any affirmative action at this point. Also, I would note that since you filed your motion to dismiss, he filed an amended petition.
And I don't believe they've modified what their arguments are. The arguments, I believe, are still that there was undue influence, which is perfectly okay. You can have influence by your family members to appoint somebody else as power of attorney if that's in your best interest. But they haven't pled that he was incapable of understanding the consequences of executing a subsequent power of attorney, which is what's necessary.
So what he asserted was that the durable power of attorney dated on July 1st, 2020 is not valid because the principal did not have the capacity to revoke the statutory durable power of attorney dated April 25th, 1996, and did not have the capacity to execute the power of attorney dated July. I mean, he clearly has said that there's a lack of capacity. I'm not sure what is insufficient about that pleading.
Well, Your Honor, that they're seeking the relief that you're going to appoint, or that you're going to revoke a power of attorney that he clearly, based on what the evidence shows, is that the power of attorney was witnessed and it was notarized, and then they're seeking the court to order that he is examined when they've presented nothing that shows that that is warranted. The only thing that they have.
Okay. All right. So I'm going to go ahead and deny the motion to dismiss. If you want to provide additional briefing about and refile this on what exactly the jurisdiction, if there's any cases that say district courts don't have jurisdiction to hear capacity arguments in this type of case, I'd be glad to see that, but I don't see anything on that.
Your Honor, excuse me. Sorry.
Did you want to say something?
Yes, yeah, I was also asking for attorney's fees on this.
Well, you filed a new petition, so I don't know that you can get attorney's fees.
I responded to the motion, but.
Well, you responded, but didn't you file a new petition as well?
Yes, just to cover myself.
You can brief that issue if you want. My understanding has always been that if you filed a new petition, that really kind of moots. We probably shouldn't have had this hearing. You probably needed to file a new 91A motion. But if you want to do some research on that and let me know if there's any case law, I'd be glad to look at that. Also, Ms. Lorenz, if you want to do some research on whether or not what exactly is the jurisdiction of district courts. I will say that I've had a number of cases where there have been issues of not necessarily capacity, but involving capacity, and we've ruled on those before. But if there's some case law out there or statutory authority that says that that's only the probate courts that can handle it, I'd be glad to look at that. But at this point, the motion to dismiss is denied. All right. Anything else?
Well, Your Honor, this case is, time is of the essence. We've got we have two individuals that are not residing in Texas. However, they clearly need some resources for care, both Mrs. Hunt and Mr. Hunt, to be perfectly frank. We have a house here in Dallas. There is also a divorce proceeding that is in the district courts as well. But we need to get some finality for this case in order to move forward with either one, selling a house and dividing the proceeds so that both Mrs. Hunt and Mr. Hunt can have resources for their medical and living needs. And so whatever we can do to expedite this, whether it is Mr. Pettigrew did mention doing a guardian ad litem or attorney ad litem, I'm not opposed to that if it's going to expedite this to get.
I think he said that was in the other case, right? Not in this case.
Okay.
But he is requesting something that could expedite it. I'm not going to rule on this today, but something you guys might want to agree on is he seems to be requesting a medical exam or something that might expedite this. I can't rule on that today, but if you guys wanted to agree to that and come up with a doctor, or you wanted me to come up with a doctor to make that determination, I'd be glad to. But again, that's not set today. But if you guys want to do that, I'd be happy to, if you submit an agreed order or you want another hearing on that or however you want to do it, I'd be glad to discuss that. Okay.
Yes, Your Honor.
All right. Anything else, guys?
I'll submit an order, Your Honor.
All right. Thank you so much. You guys be safe.
Thank you.
Thank you.
Thank you. Okay. Velocity Investments versus Gooch.
Good morning, Your Honor.
Here
I'm sorry, Mr. Gooch, go on.
I was just letting you know I'm here.
And John Kettler for plaintiff.
Okay. Let's go on the record on cause number DC 7403, Velocity Investments v. Gooch. Counsel, make your appearances.
John Kettler for plaintiff, Velocity Investments.
Ryan Gooch, pro se for the defendant.
Let's proceed. Mr. Kettler.
Your Honor, this is a defendant's motion for summary judgment, so I'll let Mr. Gooch proceed.
Okay. Mr. Gooch.
Okay. Judge, first I want to apologize. I don't have the money for attorneys, so I'm just doing the best I can. So if I do anything wrong, just my apologies up front. We have been going round and round this for quite some time now, and I'm getting help from a lawyer. And before I had submitted, I had answered all their requests for discovery and then submitted my own defense for discovery to them. And the first time they never responded back. And before I can, try to do this summary judgment, they dismissed the case and then they brought it back up. So we've been going round and round this for a while. The second time they also never responded. I don't believe that they have the right to file this charge against me or collect any
So
money from me.
essentially what you seem to be arguing is that they don't have proof that there's an assignment. Is that correct?
That is correct, sir.
All right. And there was not a response filed. Is that right, Mr. Kettler?
And I don't show a response file, Judge.
And so he's alleged, I think properly, that there was no assignment. You don't have any evidence that there was an assignment that's been submitted, correct?
Not at this moment, Judge, but I'm showing that Mr. Gooch had filed a no evidence summary judgment motion. The case has been on file. This filing has been on file since late May of this year. So based off the scheduling order and based off the TRCP, if this is under level 1 discovery, there's still an open discovery period. So I'm sorry, Judge, it looked like you were about to ask me something.
I was just going to say, did you file a motion for continuance on this hearing?
We've not filed a motion for continuance, Judge.
All right. Well, the court is going to go ahead and grant the motion then. Mr. Gooch, go ahead and email me, email my court coordinator a proposed order on the summary judgment, and please try to email that to us before Friday.
Thank you, Judge.
All right. Anything else, guys?
No, sir.
And my court coordinator, Mr. Gooch, has included her email address in the chat.
Thank you, Judge.
All right. Anything else, guys?
Nothing further, Judge.
No, Judge.
All right. It's not quite time for this yet, but is everyone here on Alonzo versus FCI Lenders Services?
Yes, Your Honor. I think this is Tim McDaniel, Your Honor. I think everybody is here.
I see Maureen
Where did Dustin
Kersey.
go?
Is Dustin George supposed to be here?
Well, he was on just a second ago, Judge, but I don't see him.
Okay.
So I guess we're not all here. My apologies.
Why don't we wait for Mr. George to get back on?
All right. Thank you, Your Honor.
It's muted on his end.
I think everyone's here now. Mr. George, are you there?
Yes, Your Honor. I apologize. I was trying to find my mute button.
That's okay. Let's go on the record on cause number DC 1818044, Anita Alonso versus FCI Lenders Services, Inc. et al. Counsel, make your appearances.
Tim McDaniel for BPL.
Candace Haley.
Dustin George for, oh, sorry, Candace. Go ahead.
Candace Haley for plaintiffs.
Dustin George for defendants BPL and FCI Lender Services.
Maureen Kersey for Blooded Bugs and 316 Capital.
Motion to reconsider. Let's go ahead and proceed.
Your Honor, first of all, I apologize for my voice. My allergies have almost put me out of commission, but I'll power through it if I can. So this is relates back to a hearing, Your Honor, that we had in the court on June 8th. And it was basically a hearing on a motion for new trial that had been filed by Ms. Haley. The court during that hearing, and the primary issue there, Your Honor, related to whether or not Ms. Haley was going to be able to supplement the summary judgment record with the deposition testimony of a fellow named Liddell Buggs, who is with 316. And the court at that time seemed persuaded that perhaps Ms. Haley should be afforded an opportunity to take Mr. Buggs' deposition and to supplement the summary judgment record, and indicated during that hearing that indeed the motion for new trial would be granted, and that Ms. Haley would be afforded an opportunity to take Mr. Buggs' deposition, supplement the summary judgment record, and then we could come back before the court on the motion for summary judgment. The court asked me to submit an order to that effect, and which I did. And I believe that that no objections to the order were filed. Mr. George agreed to it. Ms. Haley ultimately agreed to it. Ms. Kersey wanted to add something else to it, but has not submitted anything since then. And so the case then has been on hold since June 8th. And despite the fact that we are set for trial tomorrow, Ms. Haley still has not taken Mr. Buggs' deposition, and nor has she sought to supplement her summary judgment record. So I filed this motion to reconsider, basically arguing that Ms. Haley, by her lack of diligence and delay since June 8th, has waived any objection to not being able to attach Mr. Buggs' deposition testimony, and that the court should therefore reconsider its order granting Ms. Haley's motion for new trial. I will say that the underlying issue regarding Mr. Buggs' deposition testimony is that he was previously deposed, but without Ms. Haley didn't give notice to Mr. George or myself. That has been an issue in this case since April of 2019, when we filed the first motion to strike that anticipated testimony in connection with the temporary injunction hearing on this matter. So this isn't just a matter that came up in June of this year. It came up in April of last year, and despite that, Ms. Haley still has not taken Mr. Buggs' deposition testimony properly. And I think, Your Honor, based on that Ms. Haley has waived any objection to the order striking Mr. Buggs' previous sworn statement testimony. And accordingly, the court should reconsider the granted motion for new trial and deny that motion for new trial.
Ms. Haley?
Your Honor. So I would say since July 20th of 2020, we've tried to kind of get some things in place as it relates to the order. And one thing that I primarily practice is not, can you give me 1 second? I'm sorry, my TV is on, it's pretty loud. Could you give me 1 second, please?
Okay.
Okay, I'm sorry about that. Thank you. So I'll just kind of start over. So in June 12th of this year, Counsel for BPL submitted the order for you to sign, granting the opportunity to retake the deposition for Liddell Buggs. And since then, we still don't have a signed order, which I'm sure I know COVID has kind of wrecked everybody's offices and dockets, I'm sure. So I know that's probably why we haven't had a signed order just yet. But due to the complexity of this case and the issues that have arisen in this case from the beginning, I try to, and just in general practice, try not to initially or do anything without a signed order. So initially, I did not schedule the deposition because we were awaiting the signed order from the court. And so when we realized we were not, that we hadn't had a signed order in July 20th of 2020, all counsel pretty much reached out to the court inquiring about the status of the signed order, and then that it would be put before you and signed pretty soon, but we still hadn't gotten anything. And so after that, or on September the 2nd and up until October the 8th, we have been trying to schedule the deposition for Liddell Buggs. So it's not that I have not attempted to schedule, but we've had so many conflicts with scheduling that we have not been able to get it on any of our schedules. And so plaintiffs are not trying to delay or not wanting to waive any objections or have not wanted to supplement. However, just the opportunity to get it on all of our calendars, we have not had the chance to do that. And so that has been the biggest issue that we face, is just putting the date on the calendar for all counsel involved.
Mr. McDaniel, is that an accurate statement?
Well, Your Honor, I think Mr. George and I have indicated as soon as the inquiry started going out about when Mr. Buggs could be deposed, we said when we were available, and we never got dates from Ms. Kersey as to when Mr. Buggs would be available. And my advice to Ms. Haley was to just notice the deposition, and she's declined to do that. I think I asked her that 3 times, just to notice the deposition and move forward. And
so Mr. Buggs is under Ms. Kersey's client's control, is that right?
Yes, Your Honor. And your order did state that his deposition, she could take it within 20 days. I don't know if it's in 20 days of your signed order or 20 days from where you pronounce the order, but 20 days from where you pronounce the order.
So
no one
I don't know why I
it.
didn't sign this, or why I didn't get this, or whatever reason it wasn't signed. I'll go ahead and sign it now. Let's go ahead and just pick a date that we can get this thing done. So when are y'all available?
Ms. Kersey gave, I was awaiting her email. She said that her client gave her some dates, I think within the next 2 weeks, Maureen.
It was after the trial date, so I didn't think that was appropriate since it's after the trial date, since I'm sure that we're probably not going to trial tomorrow since it's scheduled for a jury trial, but
we can talk about that as well. What do y'all want to do about this? So you guys, if we're going to stay on the jury docket, we'd have to reset it to sometime probably next year.
I'm not opposed to doing that. If we can get it, I know the defendants probably want to get it as early as possible. So if there's something maybe available in January, is it all full already?
Yeah.
So Judge, the only party that's requested a jury is Ms. Kersey. And I think I can speak for Mr. George and I, we're willing to waive jury and try to move forward with this reasonably soon. The problem
You
is
get
our
to trial a
client is
lot
sitting on a-
faster.
Pardon?
Sorry, I didn't mean to interrupt you, Mr. McDaniel, but I will say you'd get to trial a lot faster.
I believe also Miss Haley was requesting a jury trial.
Oh, was she? Okay, well. I have no idea when we'll actually get to, we're supposedly going to be having a very limited number of trials, jury trials starting next month. But I mean, that's just a handful for all the district courts in November is my guess. And so I don't know when we're going to start anything that's even resembling back to normal. So if you want to get to trial relatively soon, it'd be much quicker to do a non-jury. But if you don't, if you really want a jury, I can't stop you from having a jury. So the likelihood, just be aware, is that if you do want a jury, there's going to be just a tremendous uncertainty for the foreseeable future on whether or not you'd actually go to trial. So you said, do I have any availability? I can set you whenever. For juries, I just have no idea when we're going to be able to reach you. And we might start just, I just don't know.
So
another, I apologize. Another consideration with regard to the timing of trial is nobody's paying the taxes on this property. So the taxes for 2019 haven't been paid. There's currently approximately $7,000 in taxes that are unpaid and $3,000 in penalties. And then the taxes for 2020 are also due now. So we're, and your schedule, it is what it is. I hate to use that phrase, but there's the likelihood that this property, which is the subject of this lawsuit, could be lost between now and a reset trial date. So to the extent that all parties can agree to a non-jury trial, I think that's in everyone's best interest.
Well, we've got indebtedness that's continuing to accrue at a default rate. So that's an additional problem as well.
And Your Honor, to that regard, so the defendants also filed a motion to modify or alternatively to dissolve the temporary injunction, which addresses the tax issues. However, Liddell Buggs of 316 instructed my clients not to make any further payments on the property, which is why the taxes have not been paid, because the tax payments were also included in that note. And so my clients have not made any payments as instructed by 316 Capital, which we have emails and correspondence about when the defendants have requested whether my clients plan to make those payments. I think that I could speak with my client to inquire whether she would be open to maybe if everyone would contribute to the taxes. I don't think she would be opposed to that at this time because she has been instructed not to make those payments. If everyone is willing to kind of contribute in some way, in some form or fashion, I think that can also help relieve the issue of it potentially being foreclosed upon. My client doesn't want that either. So she wants to, my clients want to contribute in some way, but they have been instructed not to make any further payments. So by the company who's actually their mortgager. So they've just been complying with that.
Okay, Your Honor, they were instructed not to make the note payment, not to do all their other obligations, such as pay taxes and insure the property.
All right, so this is what we're going to, so do you guys still want a jury? Is Ms. Kersey, Ms. Haley?
Yes, sir.
Okay, so this is what we're going to do. I'm going to go ahead and order the deposition. Well, I've just done that. Order the deposition to take place within the next 20 days. And then we're going to go ahead and reset this summary judgment on this in 45 days to get this off of dead center. So let's pick a date.
I'm sorry, Your Honor, I missed what you said.
We need to pick it. So the deposition has to take place within 20 days. And we're going to pick a new date to rehear the summary judgment because I want to be able to get this resolved. So hopefully, so let's see, 45 days would be sometime in early December. So
December 4th.
December 4th, we could do if you want to, or December 7th.
Both of those are good with me, Your Honor.
December 7th is perfect for me.
Both of those days work for me as well.
Ms. Kersey?
I don't believe I have anything on those dates. I've had to go to a different office since my office is construction and you can't hear in there for the pounding, but I don't believe I have anything on December 7th.
Okay, so we're going to reset the summary judgment for BPL funding to December 7th at 10:30. Go ahead and send a notice out.
Your Honor.
Okay, and then I've signed the order. So Ms. LaBeouf, and let me just say this, Ms. Haley, at this point, you've got to take this deposition. If Ms. Kersey doesn't give you dates, you need to do an emergency. I agree with, I don't know, it was Mr. McDaniel who said it. You need to notice the deposition and request an emergency hearing because there's not going to be any more. If you come back and say I wasn't able to get the deposition and you haven't tried to obtain a relief from me, then it's just going to be too late.
Yes, sir.
And then I'm just going to reinstate Judge Purdy's order.
Thank you.
Okay. All right. Anything else, guys? Oh, and then we need to reset the trial date. So when do you want to, or do you want to come back tomorrow to talk about that, or how do you want to do this?
If we could address it now, I think that would be good. If everyone's available right now.
So when do y'all want to reset it? I'll leave it up to, I don't really care. When do you guys want to reset it to?
I think we should try to reset it the first available date that's available to the court, perhaps in January. That way we can get our summary judgment determined and see what's left in the case.
I'm okay with that as well, Your Honor.
Ms. Kersey?
Agree.
I agree.
Okay, we'll set this for trial on January 5th. I'm going to go ahead and set out a new trial notice. And if I reinstate the summary judgment, there are still, Ms. Kersey's clients are still in it, right?
Yes, Your Honor.
Okay. All right. Anything else, guys?
That's all I have, Your Honor. Thank you.
Thank you.
All right. Thank you, guys.
Thank you, Your Honor.
You be safe.
You too.